When a person gets charged with a crime in Ontario, one of two things will happen. The officer will either let them go with an order to appear in court, or they might be held for a bail hearing. A bail hearing is a court process where a judge or a justice of the peace will decide whether an accused person will remain detained or whether they'll be released while they await their trial or a resolution of their case. If someone is being held while they wait for a bail hearing, they'll be detained at the police station or at a detention facility. According to the criminal code, that person has the right to a bail hearing within 24 hours of their arrest, if a judge is available. If one isn't, it has to happen as soon as possible. All accused persons also have an opportunity to speak with a lawyer for their bail hearing, either one that they've hired or duty counsel if they can't afford a lawyer. At the bail hearing, the Crown has the responsibility to establish why the accused person shouldn't be released, and they might provide evidence to that effect. According to the Charter, there's a presumption of release, which means that the default position should be that the accused person is released, unless the Crown can show why that shouldn't be the case. The accused person will have an opportunity to provide a plan for their release, too, to mitigate any concerns the court might have about public safety or about them attending an upcoming court appearance. When the court's deciding whether to continue detaining someone, they'll consider whether one or more of the three grounds for detention are met. The primary ground means detention is required to ensure that the accused will attend court as required. The secondary ground means that detention is required for the protection of the public. And the tertiary ground means that detention is required to maintain the public's confidence in the justice system. The court will also consider the latter principle. This is a principle that applies to all bail hearings and determines the appropriate form of release in the circumstances, with the bottom of the ladder representing the least restrictive measures and the top of the ladder representing the most. The latter principle requires that the accused be released on the least restrictive form of bail, unless the Crown can establish why the court should decide otherwise. An undertaking without conditions is the lowest rung of the ladder, then an undertaking with conditions, own recognizance, then bail program recognizance, or surety recognizance. House arrest is at the top of the ladder as the most restrictive form of release. Surety recognizance involves a person promising the court that they'll supervise the accused and make sure they follow their bail conditions. That supervising individual pledges an amount of money to the court that they'll lose if the accused doesn't follow their bail conditions and they don't report them. Surety releases are common in Ontario, but higher courts have provided guidance to ensure that less restrictive forms of release are considered and rejected as appropriate before resorting to a surety recognizance. Bail programs like the Bail Verification and Supervision Program involve a caseworker who provides community supervision to those without the financial or social supports required to meet bail requirements, and monitors compliance with conditions. If the court decides to grant the accused bail, they might get released with conditions they have to follow. This can include things like orders stopping them from communicating with certain people, restricting their access to certain locations, requiring them to live at a specific address, or imposing a curfew. If these conditions are broken, the accused person can be charged with additional criminal offenses and could be denied bail in the future. If the accused isn't granted bail, they'll remain in a detention facility until their trial. However, there is an automatic review of these decisions after 30 days for summary offenses and after 90 days for indictable offenses. An accused could also be eligible for a bail review if there's been a significant change of circumstances, like an improved release plan, or if the court made a legal error in their reasoning for denying bail.